Yes, be ready. Start. We have heard Sri Marwa appearing for the appellant state stop. None has appeared on behalf of the respondent despite notice stop. In the course of his elaborate arguments, Shri Marwa has tried to make out these points. 1. The expression any person in section 73 includes a person accused of an offence stop. Second, the word court in section 73 includes the court of the magistrate competent to try the offence or hold any inquiry in respect thereof against such accused person under the Code of Criminal Procedure stop. Section 73 does not offend Article 20 within bracket 3 of the Constitution because by giving a direction to an accused person to give his specimen handwriting, the court does not compel that accused to be a witness against himself. Stop. State of Bombay versus Kathi Kalu Ogad has been relied upon. Stop. There is nothing section 43 which prohibits the court from sending the specimen writing obtained by it from the accused to a handwriting expert for opinion after comparison of the same by him with the disputed writing, even if that expert happens to be the government expert of questioned documents. Stop. A court is fully competent under Section 73 to make an order directing the accused to write down words or figures if the ultimate purpose of obtaining such specimen writing is to enable the court trying to the case of inquiring into it to compare that specimen handwriting with the disputed one to reach its own conclusion, notwithstanding the fact that in the first instance the court thinks it necessary in the interest of justice to send that specimen writing together with the disputed one to an expert to have the advantage of his opinion and assistance. Stop. The specimen writings taken from an accused person by the court under the second paragraph of section 73 are to all intents and purposes admitted writings within the purview of the first paragraph of the section with which read with illustration within bracket C of section 45 Evidence Act clearly indicates that such specimen writings can legally be used for comparison with the disputed writings by a handwriting expert also irrespective of whether such expert is examined as a witness by any of the parties or as a court witness by the court acting suo motu or on being moved by the prosecution or the defense. Stop. The government expert of questioned documents is supposed to be a high officer of integrity who is not under the influence of the investigating officer, and he is expected to give his opinion truthfully about the identity or otherwise of the two sets of writings on objective scientific data. Stop. The mere fact therefore that in the instant case he has been summoned as a prosecution witness will not prejudice the accused, particularly when the court, in the circumstances of the case, thinks it necessary to take the assistance of the expert for reaching its own conclusion on this point. Stop. The order of the magistrate construed as a whole shows that in substance the ultimate purpose of directing the accused to give his specimen writings is that the magistrate himself wants to compare the specimen thus obtained with the disputed writing to form a just opinion about its identity after availing himself or the advantage of the expert's opinion. Stop. This course was adopted by the magistrate in the interest of justice, taking into account the conduct of the accused, who had been absconding for a long time and was declared a proclaimed offender and thus avoided to give his admitted or specimen writings at the investigation stage, and later tampered with the prosecution witness Tekchand, who was expected to prove the disputed writing and who, in consequence of the tampering by the accused, resigned from his police statement during the proceedings in court stop. In such a situation, even on the principle underlying Section 504 540 CRPC of 1898, which governs these proceedings and is analogous to the principle underlying Section 73 para within bracket 2, the magistrate was competent to use the specimen writing thus obtained for securing the opinion and evidence of the government expert with a view to assist himself in forming his own opinion with regard to the identity of the disputed writing. Over.